Hey there, welcome to the program. This is Our Healthy Homes, ourhealthyhomes.com, talking about the four pillars of a healthy home. We're talking about the house itself, the structure, of course. We're talking about the ecosystem, what's going on inside the house, and we talk about your body, strong, powerful, strong, and wise, and we talk about your emotional and spiritual well-being. We were in Florida a week or so ago. We're going to get in more depth with this. I'm excited. Next week, when we got Dr. Melissa Olson is going to be on the program. We're going to talk about longevity. But Sheila and I were at a health and wellness seminar this weekend, a longevity.
Live Long Summit.
Live
it really
Long
wasn't
Summit.
Health and wellness.
Right,
speak,
it really wasn't. It was Live Long
Summit. They had some elements of
Live
it.
Long
Anyway.
Summit.
Right.
Where there were doctors on there, 30 some docs on there, Harvard MDs, MBAs doing research on longevity. Very interesting. I thought it was going to be okay, and it turned out to be quite interesting. Looking forward to the next one. They'll be having these things across the country, and because the whole world is getting more and more interested in longevity, living long, healthy, having a good mind, and the whole health and wellness movement is catching fire, and we're seeing it starting now to filter into a lot of our real estate stuff, a lot of new construction. Pretty exciting. Anyhow, so Sheila, what do you got for programs? You got a lot of programs coming up. Oh my goodness.
I want to just back up a second to that.
Okay.
With that, the scientist that I found most interesting was the one that talked about loneliness being one of the top ways that you age yourself, and then that mental piece, and that it is an epidemic, like the loneliness, and then it turns into anxiety and depression and all that. On the loneliness side, we have a group that we meet with once a month, and last month you had asked the question to the group, how many people in here have lost somebody within the last year? And like everybody raised their hands, right? So I think that grief, the losses that people have had, I think it's just since COVID and all of that piece of it is just bigger than we think it is. And we believe in supporting you, right, with the physical, the mental, and so we have a grief class coming up. So supporting your grief naturally, and just go to the website, ourhealthyhomes.com, click on events, scroll down. There is a little button when you get to the bottom that see, next page, right?
Okay.
So don't miss that, because it doesn't end there. So believe it or not, this is hard for a lot of people to get around their head, is that a lot of people don't understand that the emotions are that you have and that you've stored in current, recent, years ago, things that happened as a child. These emotions can pop up at any time in your life.
Right.
And so
a smell or
right. Like, okay, I loved my grandma.
Mm-hmm.
I did. Okay, she had to have my bed when she came over because it was on the right floor, and she wore this horrible, cheap vanilla perfume, and she was nice, right? But she wasn't like the grandma of grandmas, right?
Okay.
And so every time I smell vanilla, I was like, ugh, right? I don't like that smell, because it
brings back memories.
It brings back memories, yes.
Okay.
So smell is huge. But anyway, so those feelings, whether they're new, old, whatever, they can come up at any time in your life. A trauma can set it off. Grief can set it off. And a lot of times grief lives in the lungs. And so if you pay attention to when you're grieving about somebody, sometimes at that, okay, let's just say May, you lost your mom in May. Let's just say every May you start having a lung cold,
right? Congestion,
so, right? So it can be because of that, right? So in our Support Your Grief Naturally table talk, if you will, We are going to talk about how grief lives in your body.
Mm-hmm.
Okay. You'll have an opportunity to share your story, but only if you want to. How the power of a scent, which we just talked about, connects to your emotions and your memory. And then we're going to create your own emotional toolkit for you. And then the importance of connecting to community. So that put me back into where we were in Florida,
Mm-hmm.
which was talking about the loneliness, and it wasn't just the loneliness as it is the grief, because grief has been so big for people, have lost so many people since COVID. So don't miss that. It's on the website. It is April 11th. And we've got, of course, what we're passionate about is if you do want to get off of medication. Now, we're not doctors, but just like us, we have a lot of modalities and a lot of resources to refer you to. Mm-hmm. Kim, who's on the show today, and like those kind of things. Like, we have the people to refer you to.
And it is a guided thing, right?
Yeah. The blood sugar.
No, the blood sugar, emotional release.
The
program.
Grief, yes.
The grief, I'm sure.
Yes. So with that, we do like to help you get off your medications if you want, reduce your blood sugar, control your blood sugars naturally, and so there's a lot of reasons why we want to do that, right? We want to prevent diabetes, and they talked about that at the summit.
Almost everyone,
type pre-diabetic, type 1, type 2, and they talked about Alzheimer's and dementia. But they didn't talk about it in the way that we see it on the natural side, having kind of be like diabetes 3. Like, that's the natural.
But they did connect the two. They definitely connected them.
Yes, they did.
In the conversation, they referred to it as a part of the issue, and yeah, the whole thing was interesting. Yeah. Like I say, we'll get into it deep with Melissa Olson next week.
So with that, then, what was the basic takeaway from all of that we seem like every scientist, doctor said? Get your sleep, right? Deal with your stress, exercise, eat right. I think a lot of people think they eat right, but they really don't even know what eating right is. And so in this Control Your Blood Sugars Naturally table talk that we're talking about, it's not only about your blood sugars, it's about sleep, it's about energy, it's about losing that visceral fat, which is around the belly, right, typically. Mm-hmm. And so let's get that visceral fat, which is going to get your blood sugar numbers down there and so forth, and basically to improve your overall health, right? And I was kind of surprised at how much time they really spent at that summit on diet, exercise, sleep, when it really is the core of our health. And we all, I think, forget those basic things that are...
Well, we're looking for some magic thing.
Exactly. We're looking for that magic pill and that magic thing when we have to come back to those four, basic elements.
And when they say exercise, they're not talking about going to the gym and working out like a mad dog for 3 hours every day at the gym. They're talking about go for a walk.
Go for a walk. And, pickleball is huge now, yeah. Right? It is a big thing, right? And so I've taken a lesson or two and played a couple games. I'm going to tell you that is a community where you just don't, you can go to open play and you can just play and people go, oh, no. They all, before you start, you huddle near the net and you introduce yourself to everybody, and then when you're done, you got to go click your paddles and say good game. Then you're off
it's like adolescent sports.
It is, and then you're off on the side waiting to play again, yeah. Right? And you're talking, and I'm telling you, more than it is about pickleball, I'm almost convinced, now it depends on what age group of pickleball you're playing with, that it is about the community.
Oh, yeah.
Because where can a person, we use Nancy, our friend Nancy, all the time. She's 78. She's amazing, but her friends aren't as amazing as her. So she doesn't have friends to go have coffee with and things like that because they can't get out of the chair and they're in an assisted living place or whatever, right? But Nancy could go to this pickleball in her element and have people that are
active
and fit and vibrant for her to have a community for her.
All right. Lots more to come. When we come back, Kim Prchal is in the studio. We're going to continue the conversation of longevity with a discussion about probate and what happens. People do kick the bucket, and when they do, their property goes into probate, and we got to deal with it. Lots of ways to do that when we come back. Thanks for tuning in, and stay with us. Hey, welcome back. Thanks for staying with us. We're in the studio with the Percolator, Kim Prchal, attorney at law.
You've never heard that before.
Never.
Never in your whole life?
Nope.
And we're talking about, we're in a kind of a probate segments of what that we've been talking about, and we want to talk about a couple of things. First, before we get rolling in, I want you just briefly, for people who haven't heard you on the show a few weeks ago, just to reintroduce yourself and tell them about your law firm and so forth and so on.
Okay, thank you. Kim Prchal. I work at Blahnik, Prchal and Stoll in Prior Lake. We have a law firm there. We have 4 attorneys. The attorneys there practice in the areas of family law and child protection, but I specifically and exclusively practice in estate planning, probate, trust administration, guardianships, conservatorships, that arena.
Okay, and that's exactly what we want to talk about. Last time when you were on the show, we did spent quite a bit of time just talking about probate and the probate process. I want to kind of back up a little bit and talk what people could have been doing in preparation for this a couple years earlier. We had a closing earlier in the week, and immediately they asked, okay, so now what should we do? Should we put this in a trust, or how should we do that? Actually, her father was asking. So we had a little conversation about that. So let's talk about trusts, if you can.
Okay.
I really want to talk about wills.
Okay.
And I want to talk about trusts.
Okay.
And then what was the last one? Conservatorships?
Guardianships
or guardianship?
And conservatorships.
I want to know the difference between those two.
Okay.
So let's talk about wills first.
Perfect.
Do you really need a will? I mean, if you don't have $1 million in the bank and a Rolex watch, do you need a will?
It depends. It depends specifically on the types of assets that you own.
Okay.
So we know that there are only 2 types of assets that trigger probate, right?
Right.
So just to make sure everyone understands who's listening, if you have a will, it's going to probate, right? So if your will is involved in the administration of your estate, it's being filed in probate.
Okay.
So
the will is going to probate.
Correct.
The estate is not going to probate because of the will. It just know that the will is going into probate.
Correct.
So the will does not usurp probate.
Correct.
Okay.
And that's a really big misconception out there is people think, well, I have a will, so my estate is not subject to probate. That is completely false.
Okay.
Okay, so the will governs probate assets. So we only have 2 categories of that. It's real estate in an individual's name alone at the time of death.
Okay.
And personal property in excess of $75,000.
Okay. Clarify real estate in an individual's name.
Real estate is anywhere, any location that you have real estate.
Well, okay, so I'm talking about Minnesota real estate right now because of me, I'm talking about Minnesota residents here.
Okay.
Mm-hmm.
But to just briefly explain, if you own real estate, no matter the value, it will trigger probate. Then second, because you asked this state question, if you own real estate in another state, that could be what's called an ancillary probate proceeding. So now we're talking about the potential of two probate proceedings, okay?
So you got that vacation house in Florida.
There you go.
Yep.
Right. So now we're doing probate here in an ancillary in Florida. And we're going to circle back to that because I want to tell you about that.
Okay.
But let's answer your question. Individual's name alone. Why do I say that? Well, because, for example, you two, you own your home in joint tenancy. We talked about that earlier, right? That means if you die, it all goes to you. You die, it all goes to you. So there's going to be no probate for your house on your death because it's not an individual's name alone. It's joint tenancy.
Okay.
But on her death, if we don't do other types of planning, that is when probate would be triggered. And if
Because now I'm the only one
you're
left.
the only individual owning that real estate.
Okay, let me ask you this question, Kim. We have a closing, and they say, do you want to go joint tenants or tenants in common?
Yes.
So explain the difference there, and how does that impact how I'm going to draft that will, and how does it flow into
deed.
probate?
How you're going to draft that deed? You mean?
Deed or will subsequently.
Okay.
Yeah.
Yeah.
Okay, so the difference between joint tenants and tenants in common is this. Joint tenants carries with it a right of survivorship automatically embedded in that definition.
Okay.
Tenants in common contains no right of survivorship. So that means if you two own a house, let's pretend you're not married because then we get into family law.
Yeah.
Not married, you own a house as tenants in common.
Two brothers bought a house.
Two brothers.
Okay.
Brother 1 gets to do whatever he wants with his 1/2 interest. Brother 2 does whatever he wants. If they make no plan, so this would be a perfect scenario where a will might change the course of what happens to each brother's individual estate.
Okay.
Brother 1 doesn't do a will. So when he dies, the laws of intestacy determine where his 1/2 interest goes. Maybe he's married and it goes to his spouse. Maybe he's not married, it goes to his kids. Maybe he was unmarried, had no kids, and now we have to figure out who the heirs are of his estate.
Okay.
Okay, so what if it's nobody?
Well, we go up to parents. So if his parents are still alive, it would go to them. Then we start at parents level and go down to his siblings. Well, we know he has a brother. So it may go back to him.
Oh.
Or it could be
Bonus.
split
Bing, bing.
between 5 other siblings.
Or that.
Correct.
Okay.
Okay. All right. So tenants in common, let's say brother number 2 over here had a will, and his will specifies, I want it to go to my brother, right?
Uh-huh.
Well, it would have gone to his parents if they were still alive. So he is specifically choosing who his beneficiaries are and not relying on the laws of intestacy. So a will would benefit him there.
What happens if in the will they says, I want all of my estate to go to the church?
Yes.
And it just doesn't specify, it just says I want the entirety of my estate to go to the church.
And it specifies which church?
Yeah.
Yeah. Oh, yeah, you can do that. You can name...
So now suddenly as the other brother on
Yep.
that deal,
You're owning a house with a church.
I'm in partnership with the church.
Correct.
Interesting.
Yep.
And then
So let me just explain one thing. So
Okay.
the will.
Mhm.
So in addition to actually choosing who your beneficiaries are, which, maybe I'll use myself for an example.
All right.
So, right, if I didn't have a trust, my laws of intestacy would say if I die, I'm married to my husband, Eric. He would get everything because the children that we have are joint. But now let's create another hypothetical, and if my husband's listening to this will be interesting. So the hypothetical is we get divorced.
Oh, yeah.
Okay?
Hypothetically.
Hypothetically.
Underline, underline.
I get remarried, and I
Oh,
have
yeah.
2 additional children
Yeah.
with someone else. Well, now when I die, the laws of intestacy say that if I get remarried, that spouse in my house would get a life estate only. Well, maybe I want everything to go to my new spouse. Then I would need to do a will because
Okay.
the laws of intestacy are going to protect my non-joint children.
okay.
So
From the previous marriage.
From the previous marriage.
All right.
So you hypothetically.
Yes. I'll text him right
remarry,
now. Don't listen.
and then, okay, they have kids.
Yep.
If somebody adopts kids, is it different?
Well, so if my new husband hypothetically
Yep.
adopted my other 2 kids, that would change the results.
Okay.
But not if you two adopted a
Third
child.
party kid.
Yeah.
Oh, yeah, we can adopted children are treated as long as they're legally adopted, they're treated as your biological children in this state.
Okay.
Yep.
So when we're talking trusts now,
Yes.
it's property in, property out. So many people form a trust
Yes.
and then never put the property in the
Yes.
trust. Tell us about that.
They never do what?
They
put
never
the property in.
Oh, got it. Yeah.
it's really frustrating for me to review these trusts, and I just had one come in yesterday where people have maybe spent $4,000 or $5,000 on a trust, and one, it's either unfunded, that's what we call it, there's no assets in it or no assets available or going to it upon death, right?
Okay.
We are okay with that in this state. Minnesota trust law says we can have an unfunded trust that's not funded until death.
And then put it in the will?
Nope, you put it in, you use a transfer mechanism. I'm going to use the transfer on death deed that we talked about previously.
Okay.
Remember?
Yes.
So
yeah.
you say, upon your death, your house goes to your trust. That way, during your lifetime, if you want to sell it, you're not selling it as trustees of a trust. You're just selling it as you two.
There's not a problem with selling it as a trustee with a trust anyhow, is there?
Well, it complicates the sale a little
bit.
So a lot of title
Different kind of a
companies,
deed.
yeah, they don't want to draft those trustee
Mhm.
deeds. You have to do a certificate of trust, affidavit of
Yep.
trustee. Here's the key part, though. When they go to sell it, they're issuing the check to the trust.
Yes.
Well, some people haven't set up bank accounts in their
No.
trust,
Right.
right?
Yes, right.
So now we've complicated the proceeds. So sometimes for ease of funding, we like things going upon death.
Okay, so then when we come back, I want to continue on
On
with trust. So then would we pull it out of the trust prior to selling it?
Some people do that.
I know.
Yeah.
And then same way with financing, because you finance, you can't get a loan with a trust.
Right.
So they close on the house, then they put it in the trust.
We leave the mortgage always outside of the
Right.
trust. Leave it in your individual
Yep.
names. It's secured by the
Property.
property,
Asset,
so
yep.
we don't worry about it.
Okay. We got to head out to break. We're talking with the percolator, Kim Prchal, and we are talking wills, probate, trusts, and we'll talk more when we come back. Hey, welcome back. Thanks for staying with us. We're with Kim Prchal. We're talking about trusts, wills, estates, probate, guardianship. And I have a question that I thought about just over break that I just want to touch on before we get back into wills and trusts, and it kind of ties in. So I have a property here in Minnesota. It's in the trust.
Okay.
I have a vacation home in Colorado, not in a trust.
Yes.
So how does that all work?
Okay, I'm going to change your hypothetical a little bit
Okay.
to illustrate why it's important. So hypothetically, let's say you didn't have the trust, right?
Mm-hmm.
And
Didn't have the trust
you didn't
here.
have
Okay.
a trust.
Okay.
Okay.
So this is the question of why would I get a trust? Why would I have a trust?
Good question.
Right? Not everyone needs to avoid probate. If you're a single person, you own one house and you have a house going through probate and you have a will that says where it's going,
Yeah.
not that big of a
Not
deal,
that big of a
right?
deal
Not
at
that
all.
dangerous.
No.
But let's say you have the house here, and just like your example, you also have a house, but this time we're going to say California.
Mm-hmm.
You have this house in California and a house here. Well,
Are there squatters in the house in California? Or is it...
no, it's being rented and they're paying top dollar.
Okay,
So it's a
super
good
duper.
investment.
All right.
Yeah.
All right.
And you bought it for like $400,000 and now it's worth $2.2 million.
There
So
you
things
go.
are looking really good
Okay.
for your heirs.
All right.
Okay, so every state's laws on probate are different. And this morning, I just looked up California's because I have a client that has a house in California. And they're thinking they're asking the question, should we try to avoid probate? And I've always heard that California probate, in addition to Florida, they're nightmares.
Okay.
Okay.
So here's what I found. California probate attorneys are paid a percentage of the value of your gross estate.
What?
Oh my gosh. So we are not allowed to do that here. We're strictly precluded by our rules of professional responsibility. So what they ding you with out there is the first 100,000, you have to pay 4% of your gross estate to the probate attorney and the executor. Then the next 100,000, you have to pay 3%. And then the next 800,000, you have to pay 2%. So for a $1 million estate, you have to pay 9% in probate and a probate attorney fees and executor fees
To the attorney.
to the attorney. $90,000.
Wow.
Okay?
Wow. What are you going to do? Get your license?
Well, I'm thinking about it, honestly. No. I just
Keith, get your license.
So we have to be aware that one of the reasons to have a trust, and this is always one of my factors when clients are like, Kim, do you think we need a trust? Because not everyone needs a trust.
So the takeaway is not everyone needs a trust.
Correct.
And there's so many variables.
Sometimes it's better not to have a trust.
Sometimes it's overkill for a
And you
trust.
need to talk to a professional to
Yes.
find out which case you fall into.
Yes.
Okay.
And I think that like anything that ebbs and flows and comes and goes, and can my wide-legged jeans please come back? But
They are.
you
You can
know,
do it.
right? But it's kind of like that, right? Where oh my gosh, everybody's doing the transfer on death deed.
Yes.
Everybody's doing a trust now. Everybody's doing this. It really is important because of everybody's situation being so different, like this California thing.
Yes.
Like, wow, you need to talk to somebody that knows what they're doing. To
Well,
be able
it's
to,
so in the community, I always get asked with very similar question to how you started this out. Does everyone need a will, right? And if I do, Kim, what's wrong with the legal Zoom, right? I can just whip out a trust or whip out a will, and it's right there, right? What's wrong with that? Well, I've reviewed some of the legal Zoom wills, some of the legal Zoom trusts. Maybe they will get the job done, but here's what they're missing. The advice on which of your assets is this document actually going to control. Do you even need the trust? I met with a lady this morning. She has a trust. It's a generic trust, not specific to any state. I guarantee she got it online, right? But she had no idea how this was going to work. You need the document, but you need the advice behind the document.
We talked about trust in, trust out, property in, property out of the trust. We've had, the famous case, of course, is with Steve Jobs, who took real estate out of a trust to refinance it and neglected to put it back in the trust. So that, it got tied up in probate in California, in which case he's given up 9%.
Or more, because
more.
Once you have $2 million, it jumps up another couple percent. I mean, it just keeps going.
So
Scale.
with that, now I kind of okay. So let's say that you forgot to put the property in.
Yes.
And so you realize, oh my God, I'm gonna check on that. We never put that property back in. And you go that was 10 years ago. That attorney now is gone.
Yes.
Retired. How do you do it?
Okay, so this is why I love the transfer on death deed. Because then if you need to refinance, you don't have to do anything. The deed is just done.
Okay.
It says upon your death, it goes to the trust.
Perfect.
It's the best solution, because I've had several probates where it was taken out for a refinance and they forgot to put it back in. Plus, guess what? You're paying me every time to do that,
Sure.
right? The transfer and death deed is a one and done deed,
Now let's go. You forgot to put it back in the trust.
Yes.
Okay. Let's go to the transfer death deed. If the person that you transferred the death deed to died, the same thing, don't forget, you need to change that transfer on death deed to somebody else.
Right, because it's void.
Right, because it's void, right? And so.
But the trust isn't going to die.
Right, but my point
If
is
it's to
that
a
you just
person.
forgot to change that. You forgot to put that back in with the mortgage, right? It's the kind of same thing as people just think, oh, I have that transfer of death deed, and you can forget, like,
to reevaluate your estate plan. Well, and here's the other thing. Transfer on death deeds, a lot of people don't realize this. You can put a contingent beneficiary right on the deed that says if Kim Prchal dies and she predeceases me, Sheila Hittner is the new beneficiary.
Right.
Where do I
Keith
sign?
Hittner. Keith Hittner, want me to spell that last name so you get it correctly?
Right.
Okay.
Where do I sign?
So now, did we do ancillary?
Yes.
Yep.
So what the cautionary tale there is. So not everyone needs to avoid probate. But if you own real estate here and real estate in another state, you should probably be looking at a trust, because we know that trust planning can avoid both probates, and we're going to save you money by doing that.
Okay. So, but if you have a trust here,
Yes.
Can you put real estate from another state in
You can.
In the Minnesota trust?
Yes.
Okay. So if the property's in California and you put it in the Minnesota trust,
Yes.
then how does that work from settling the? Oh, it's out of the probate. There is no probate.
Exactly.
Okay.
Does it matter?
Got it.
Does it matter if your homesteading is half and half? Does that have anything to do with, I'm here 6 months and here 6 months?
Well, so the way I do things with the transfer on death deed, you don't have to redo your homestead classification. So California also has a transfer on death deed. So what we don't know, for example, in that hypothetical, is not all states let you have an unfunded trust. But we're talking under our hypothetical that it's a Minnesota trust, and we allow that. So you would just use a transfer on death deed to avoid that exact situation.
Okay, so let's talk about guardianships.
Yes.
So it's guardianship and what was it?
Conservatorship.
Conservatorship.
I'm so excited
So
right now.
tell me, explain the difference
Okay.
between the two.
So many people come to see me for estate planning, right? They're
Mm-hmm.
always, do we need a will? Do we need a trust? And what happens if we die? But I'm sitting there with those people thinking, right, you're my client. So like, as much as I might eventually meet your beneficiaries, I don't really care about your beneficiaries.
Right.
I care about them only in the sense that you care about them.
Right.
But what I really care about is my clients and their health and well-being during their lifetimes, right? So this is the incapacity side of estate planning.
Okay.
So what we're doing is we're making sure people have healthcare directives and we're making sure people have power of attorney documents. Because here's what a guardianship is. If you have nobody that you have specifically named to make medical decisions for you when you are incapable of making those, you're going to court to get someone appointed as their guardian with full control to make those types of decisions, right? Conservatorship is if you haven't named someone to make financial decisions on your behalf. So tying to real estate, let's say something happens to you, right? You've become incapacitated. I was like, we'll do this one for now.
Okay.
I'll come back to you later. So
I'm always the fall guy.
Yeah, you're incapacitated. And Sheila's realized, I can't take care of this house, take care of him, so I need to like downsize, right? So she needs to sell the house. You can't sign. Right? Even if you could sign, you don't understand what you're signing. So she's never going to be bringing you anywhere because they're going to no, you don't have capacity. She's going to court to get appointed as your conservator to make financial decisions on your behalf.
Okay.
You're still alive.
So even though she's my wife.
She has no authority.
Okay.
So power of attorney would give her that authority.
Okay.
1 minute. Power of attorney gives her the authority to say, I'm selling the house and I'm signing for him and signing for myself. If there's any proceeding that you should avoid in this state, well, Britney Spears, you can see how that went. It's a guardianship and conservatorship. I'd much rather deal with a probate for beneficiaries than have someone petitioning the court to be the guardian or conservator for their spouse because it's an adversarial proceeding.
Okay. And they can do whatever they want with it then, as opposed to being directed by
the courts.
Okay.
Yes.
This is okay. So we're gonna go out to break right now. Pay some bills, and we'll be right back after these messages. Welcome back. Thanks for staying with us. We're speaking with Kim Prchal. We're going through the whole probate process. Wonderful conversation. We talked about trusts, property in, property out. We're talking about probate in other states. And trusts in this state, the fact that you can put a trust in Minnesota and put properties, was news to me. If you have a property in Texas, you can put that Texas property in your Minnesota trust.
Yes.
Beautiful.
Yes.
And protect it so you don't have to do probate at all. We talk so much time, we talk about avoiding probate. The fact of the matter is, we work with a lot of probate clients. I specialize in it, as a matter of fact, and many of the cases, most of them, are not in a trust.
Yeah.
It's just a house, and the probate process itself is not like this burdensome thing. It's a little clunky.
Yes.
And I would highly recommend to anyone listening, it's not a DIY thing.
Yeah.
Because you can get into miss some things, and it's not the end of the world, but it will delay it. You can find yourself at the closing table, as you mentioned in a couple of segments ago, with a check and no place to go with it.
That's right.
Which happens many times. Sheila, what'd you have?
Nothing.
Okay, you're waving your hand like you had something
I did
very
have
important.
something,
You were ready to interrupt me. Very important, and now you have nothing.
It was going to go down a different rabbit hole.
Okay.
So okay.
All right. So when we went out to break last time, we were talking about guardianships and conservatorships. I'm
Yes.
still a little confused about the difference between the two.
So the primary difference is, think of it all as guardianship is personal decisions. Where you live, the medical treatment you have, food, shelter, all of clothing, your personal decisions.
Okay.
Conservatorship is all financial.
The money side.
The money side of everything.
Okay, so what happens now? There's all these scenarios, and I'm sure you've dealt with all of them because so many things come up, and it's all great when the thing was set up.
Yeah.
And so now I have is it common for the same person to have to be the conservator and the guardian?
Yes.
Okay. So we're all set up. I'm the guardian and the conservator for my grandson.
Okay.
And as I age, I start having some issues myself.
Yes.
What is the protection? Hypothetically, honey. Hypothetically.
Yeah, okay.
What would be the protection then of my grandson or granddaughter or whoever I'm
Me.
operating on behalf?
Your wife.
What is their protection if I start losing it?
Well, so let's go back one step. First of all, we never want a guardianship or conservatorship, right?
Oh.
Because Minnesota has other options for us.
Okay.
Okay. So we want to avoid that proceeding whenever possible.
So that's last resort.
Last resort.
What's first resort?
Healthcare directive
Okay.
that says if I become incapacitated,
Mm-hmm.
if I am unable to communicate, she's making all my decisions.
Okay.
Right? And if she's not available, you're naming whoever you want to.
But isn't that
next.
essentially the same thing? Aren't we essentially talking
Except
about
for
the
it's
same
a
thing?
private document and you never had to go to court.
Okay.
Right? So guardianships are they're set up to be adversarial. And what I mean by that is, let's say she's going to get guardianship for you. So she has to file a petition in a public proceeding detailing how incapacitated you
Okay.
are
All right.
and what you're doing. Now that's a public document
Okay.
that anyone can read.
Right.
Second, what the court's going to do then, and she probably had to hire an attorney because
Sure.
just like probate, this is not a
Absolutely.
DIY thing.
Right.
You also get appointed an attorney of your own
To advocate on my behalf.
to advocate on your behalf because the
Okay.
presumption is she's trying to take advantage of you.
Okay.
Okay?
That's the default assumption.
That's the default assumption,
Probably
right? Because
valid.
we're restricting
Probably valid, knowing the lovely and talented Sheila.
because we're restricting your civil rights. So
Okay.
that's why the standard is high. Not only do you get your own attorney, you're also going to get a court visitor that's going to come out and talk to you and talk to her.
Make sure I'm really.
Make sure you're really incapacitated.
Okay.
Guess who's paying for all of this?
Me.
Mm-hmm.
And then if it is granted, it actually becomes
Sure.
the responsibility of your estate to
Right.
pay for all these lawyers, the court hearings, etc. If you would have just had a healthcare directive, all of that could have been avoided, and I draft those things for $200.
Okay. So then, what about the financial
Finance.
side of
Perfect.
things?
Finances. So that's the conservator side. Again, even more so than the guardianship, we want to avoid a conservatorship. So let's go to why.
Okay.
So first, in order to avoid that, if you would have named someone as your power of attorney, or we technically call it an attorney in fact,
Okay.
to make financial decisions for you, if you cannot make your own, or just generally speaking, like my husband is my power of attorney. If I needed to call him tomorrow and say, hey, I can't attend our closing tomorrow, can you go and sign for me? I've named him as my attorney in fact right now. He doesn't even need to wait for me to be incapacitated.
Is
okay?
there any term on that? Because we do for real estate, we do that, but it's only for this transaction.
Only for that transaction.
Yes, you can limit it to the particular transaction. You can limit it in time. Some people will have appointed me as their attorney in fact to attend a closing. I'm only their power of attorney as it pertains to specific real estate, and it expires a month from now.
Okay.
Right? So having a power of attorney allows someone to make financial decisions. So let's go back to you're incapacitated and she doesn't have a power of attorney. She's petitioning the court to become your conservator. Now here's where things get really ugly. Not only do we have the adversarial proceeding, but let's say the judge agrees with her and grants her petition, and now she is your conservator. Every single transaction you make on his behalf, every single debit that or income that comes in and out of what was your joint account now has to be separated into his name only, and you have to keep track of every dollar. You have to upload every receipt. You have to upload every bank statement. The Minnesota Conservatorship auditing program is going to audit you, and then the court has to approve those annual accounts.
Nasty.
For your spouse, because you didn't have a power of attorney. So if there's any takeaway here, even as it pertains to real estate, you're selling the house because your spouse is sick and you need the money. You need
Right.
to move, but you don't have this. Your first step is going to court.
What happens if you
Hypothetically.
under advisement, bad
Yeah.
advice, you form a conservatorship,
Okay.
and one of the children says,
Mhm.
she's taking advantage of Dad, and we need to step in. What does that look like?
Well, so that's the interesting part about Minnesota law is that when she files this petition, she has to give notice to all of your children, 18 or older. She also has to give notice to your siblings. So all of them will
Wow.
get the notice of hearing, and it'll be via Zoom because Minnesota is Zoom hearings for this type of law. And they can all show up. And your child could say, she is trying to take.
But maybe at that time it's like, yep, let her do it. We don't want to do it. Let her do it.
Okay, so they let
5 years later, they're like, man, she's taking him to the cleaners.
Yep, they can. So they're entitled to receive your accountings every year.
Okay.
They're entitled to receive your inventory. And then every year she has to do these accountings. So if they are objecting, it's likely because they have seen something in the accountings where Dad started out with $5 million and in 1 year he's down to 2. Where did the $3 million go, right?
Okay.
They can object to the allowance of that accounting, and now there will be an evidentiary hearing or a mini trial on that issue.
Do you go to those?
I represent people at those.
So is this a very infrequent thing then in Minnesota? It sounds like it should be.
It's not.
Really?
I mean, we do a ton of guardianships and conservatorships because I think it is just education out there that these 2 documents could save you so much time and headache, and people wait too long. They wait till someone's sick. They wait until they're older, right? My sister turned 18. I'm like, here's your healthcare directive. Congratulations.
Yep, you're
because she was
18.
going off to college.
Yeah, your
and
power
I'm
of
like,
attorney.
I'm not dealing with that, right? Yep, power of attorney.
And your health-
So, I mean, anyone 18 years of age or older needs to have these 2 documents.
So what is the difference between being attorney in fact, which you stated for this,
Yeah.
and personal rep, which is what we find out with probate?
Okay. So, attorney in fact is regarding power of attorney, and here's the unfortunate part. Power of attorney is void at death.
Okay.
So you
Oh.
can't do anything after death. So that's the personal representative takes over after death according to the terms of someone's will. Now, what we've talked a lot about here today is that some cases shouldn't go to probate. We shouldn't even have a personal representative. If you own assets in more than one state, if you have beneficiaries that don't get along, if you own a business, you should have a trust, and then your trustee takes over.
And then he's the personal rep.
No, because
Yeah.
we won't have a personal rep because
Oh,
we have a
he's
trust.
That's who he's trusted.
We'll have a trustee.
Okay. Okay.
Okay.
Because many times I've heard this a lot of times, where Grandma kicked the bucket, and one of the kids had a power of attorney and had been operating for years and all this stuff. And you go to sell the house, and don't worry about it. I have a power of attorney, and it's like, well,
Yep.
no
And
more.
We get those calls because they'll say, I had power of attorney, and they went to sell. They signed the listing agreement, and then when it came to closing, the closing company figured out that they were operating under power of attorney, and that's the point in time we're going to have to commence probate.
So we need to update our our will because we owned the Rack Shack barbecue
At the time.
at the time, so we have some language in there about that, and we no longer own that.
Yeah.
So it would be wise to
do
redo it, right?
Just an evaluation, and I do 30-minute consults for free for people to say, hey, let's sit down.
Free is good.
Free is good.
What's the number to reach you?
952-447-4424. Again, Kim Prchal.
And we'll put that on the podcast at Spotify and on YouTube. We will see you next week, kids.
But when he calls me sugar, I love that man with all my might. Sugar in the morning, sugar in the afternoon. Sugar after dinner, sugar in every room. When he calls me that name, it does things to me. I tell him, honey, you can call me sugar.